Good evening, ladies and gentlemen, fellow attorney-CPAs, spouses, and supporters. I thank you for the opportunity. Through modern technology, I am able to participate to a degree in your deliberations and your celebrations. First, let me thank Phil Cass, who's sitting beside me and is my technical advisor, without whom I would not be able to talk to you.
You're welcome.
That said, I'm told that I only have like 10 or 15 minutes to try to capsulize what occurred in many decades. Well, I have to be relatively brief. So, rather than start with our genesis, I'll start with 1861, when President Lincoln had the first income tax law adopted. This law, however, was found to be unconstitutional by the Supreme Court in 1895 because then Article 1, Section 9 of the Constitution provided that you could not have a tax unless it was based on the census or population of each state and apportioned accordingly. But in 1913, the Constitution was amended by Amendment 16, authorizing Congress to adopt an income tax, which it did in the year 1916. And then the Internal Revenue came into being, and our first income tax return was being utilized. I mention this because, in contrast to the one-page income tax return that they used in 1916, compare that to the 50 or more pages that we have to go through in many cases for an income tax return that nobody really fully understands. But that said, there was then a budding need for people who understood the tax law. And the IRS enabled anybody who passed a certain examination to practice. CPAs naturally wanted to practice tax law because that's what they understood and that's what they did best. However, the Bar Association felt that accountants were impeding on their turf, and therefore, although they wouldn't say it directly, it would affect their overall income if what they considered to be the practice of law was done by CPAs and not by attorneys. So, they started issuing opinions, chipping away at the right of an attorney to have an ancillary business. And specifically, they came down hard on attorneys who were also accountants. However, there were only a few at that time in the early 1900s. But comes World War II and the return of the GIs who took advantage of the GI programs that allowed them to go to college with the government paying tuition and paying their expenses, so that hundreds of thousands of young men who would not otherwise have gotten an advanced education undertook this advantage. Many of them studied accounting. So our ranks grew because many of the accountants became attorneys. Now, at that time, the ABA had issued approximately 15 opinions that said that it would be unethical because you can't practice because it's a feeder solicitation, you're advertising, and the then canons of ethics, Canon 28, specifically said attorneys cannot advertise, solicit, or tout, meaning holding out. Comes 1949, and a CPA in New York City is retained by his client to conduct a sales tax audit representation with the city of New York. He was very successful in applying as he understood the law, and with his accounting background, he was able to get a very favorable result. He sent the bill to the client. The client showed the bill to his attorney, and the attorney yelled, "Oh, unauthorized practice of law. You can't do this. Don't pay it." Well, he didn't. And unfortunately, or fortunately, the courts in New York determined that this was the practice of law, and therefore the unauthorized practice of law did not entitle the CPA to be paid for his service, not even on a basis of quantum merit. That said, very many CPAs were prompted to go on to law school, and the number increased significantly. The ABA in the late 1940s, 1948 I believe, was so incensed at the fact that so many CPAs were practicing tax law that it then started a campaign. Firstly, they adopted Opinion 272, which ratified all their prior opinions. 272 saying that you cannot carry out an ancillary business because that's touting, and you can't have it in the same office. Fortunately, there were a group of some 12 or 13 attorney-CPAs in Los Angeles who, when they found out that the California Bar Association was seeking to implement this ABA opinion, they formed an organization, they retained an attorney, and the bar never proceeded to implement those prohibitions. Nevertheless, the ABA persisted, so that in 1961, they adopted an opinion 297, which said, you can't do this, Mr. Attorney CPA. First of all, you're not capable of doing it. Secondly, you're advertising. Thirdly, you're soliciting. Fourthly, you're touting, which means holding out. Therefore, it's improper. They attempted to get the AICPA to go along with them. However, AICPA since 1941 had issued an ethics ruling that they had no objection to dual practice. That said, the California Association again filed a brief in order to offset the implications of 297. And again, they were reasonably successful in that it was not being enforced in California. They wisely communicated with CPAs all over the country, and I received one of their letters suggesting that state associations be organized to confront the critics of dual practice. I thought it was a great idea. I spoke to several other attorney CPAs who agreed, and in 1961, we organized the New York Association of Attorney CPAs with approximately 12 people at the outset. It should be noted that Massachusetts also organized an association through the efforts of Elwin Miller. Elwin turned out to be our third president and was very instrumental at the beginning in helping us proceed with our objectives to protect the dual practice. However, 297 was not enough for the Bar Association. The New York Association, parenthetically, had grown from 12 people to over 200 people by the end of 1963. In the interim, in 1962, the Bar Association, American Bar Association, adopted another opinion, 305, ratifying everything before, and in effect saying, you must practice one or the other. That impetus caused the New York Association and the Massachusetts Association and the California Association to try to do something on a state level. I was successful in getting on the New York State Bar Association Committee on Professional Ethics, and when the time came to determine if they would accept opinions 297 and 305, we were there to confront them with the reasons why it would be improper. We succeeded. We, in New York, decided we would like to have a convention. We had 200 members, and we planned one for the Concord Hotel to take place in October of 1964. In the interim, Jay Foonberg and others similarly minded felt that we should try and strive to continue to encourage state organizations. Some of us, myself included, felt that only a federal or national or American association would be able to confront other national associations. So we determined that it would be wise to start an American Association of Attorney-CPAs. We wrote to practitioners of our knowledge all over the country. Make a long story short, we had representation from 11 states. We had some very noted attorney-CPAs there. One in particular, Robert Musselman, was a gentleman that I had met on a legal matter. He was a professor of law at Virginia University, and was also the author of Musselman on Taxation, which in the early 1950s was the Bible for taxation. These 11 states were represented by a total of 60 people. 38 of that group signed the charter authorizing the creation of an American association. 28 people were too fretful, were too afraid, and declined to sign. And this was representative of dozens of other practitioners who, not wishing to be accused of unethical conduct, were abiding by the ABA preclusions and were giving up their accounting and or law practice. Now, you might say the ABA has no ability to disbar or to hurt people who don't abide by their opinions. However, when the states adopt ABA opinions, they become law. And if you are guilty of unethical conduct, breaching these codes of ethics, that's grounds for disbarment. Well, it was something that we felt we had to overcome. The American Association met initially with the American Institute of CPAs and received a very favorable response that their 1941 ethics opinion permitting dual practice would not change. They only asked in exchange that attorney-CPAs recognize that there might be a conflict if that practitioner was both the attorney and a CPA on an independent certified audit, because the attorney had to be a confidant and had confidentiality, and a CPA had to be a disclosure. So there was an obvious conflict. This was a small thing to give up. Now, the ABA was still trying to have their opinions implemented, and we confronted them. Because time is running out, I'll tell you that we were successful. We were successful because we had an audience with the right committee through the good efforts of Elwin Miller, and convinced them they were in a process of changing the canons of ethics to the rules of professional conduct to change their attitude. They did, but only to a point, saying that it was all right to have dual practice, but you should have it in separate offices. We persisted, and fortunately, our efforts coincide with a slew of U.S. Supreme Court decisions on free speech, saying that commercial free speech was entitled to the same protections as political free speech. That was the death knell to the ABA's limitations on our right to hold ourselves out, to advertise, and to act in a professional manner in our both professions. Free speech, Amendment 2 to the Constitution. Or was it Amendment 1? Anyhow, we thought the problems had been laid to rest, but several years later, the Florida Board of Accountancy brought charges against one of our members, Sylvia Arbanez. God bless her, she would not succumb. And with the help of the association, financially, and with the efforts of our member, Professor Harold Levinson of Vanderbilt Law School, we were able to aid in great part Sylvia's endeavors. Now, you're fortunate in that one of the programs will be a presentation by Sylvia. And God bless her. I'm sure she'll be able to give you all the details and all the answers as to why we succeeded in that particular instance. However, many feel that the association initially was a good defense mechanism and has no reason for existing. I respectfully disagree. In 1953, I was on a panel with the New York State Certified Public Accountants along with Richard Oren, and I saw immediately I had more in common with another attorney-CPA than I had with just an attorney or a CPA. Now, it makes sense that our organization should thrive because we offer unique programs. The ability for a newcomer to utilize our internet and get advice from experts all over the country on problems is not available elsewhere. Furthermore, there are programs that we have that should be activated, and perhaps you will consider them in your deliberations. One is the American College of Attorney-CPAs, which recognizes that an attendee had accumulated enough credits by attending our technical sessions to be awarded a degree. I am very positive that the efforts of Mitch Rabel and Alan Webster, who created the American College, will not go unnoticed and will be activated. I want to thank you all for this opportunity to be with you, and I look forward to most of you celebrating the next 50 years.